Set the standard. I think I ought to stand up. The title of this session is Critical Issues in Drafting Patents and Claims. And I think that's a very useful sort of thing to start with. But I tend to look at things from a slightly different perspective. And that is that there are critical issues, but the question is, why are they critical? And it requires one, in preparing patent specifications and generating patent assets, to come back down to the fundamental purpose of why are we doing it? Why are we filing a patent application? What do we try? What objectives are we seeking to achieve? So I tend to look at it very much more as creating value through the business of patents. None of us in patent law firms or in patent departments would really have much to do unless there was a business there for which there was some value that needed protecting by way of innovation, different processes, different products, ensuring that there is freedom to operate from the rights of third parties. Now, we can all, as patent attorneys, write a patent specification, and we can write a claim, and we can give it to an inventor or to a manager, and they can look at it and say, yep, that's great, that protects the invention. And that is, of course, critical, but if one stops there, then you may not, in fact, be really creating value for your client or for the industry within which you're working, because you have not necessarily thought about much more than just simply the technical aspects of the invention. So the reason why one starts in this process and spends the money and engages in a long process is because there is a client or a company that wishes to sell a product. And it wishes to sell a product ideally with patent protection, where there is an opportunity to stop other people coming in to the marketplace with a copy of that product. And so a patent position must protect that fundamental business. Could I have the next slide, please? Thank you. So when I write a patent application, I start off by thinking about not the invention or not the anything technical, but I speak to the client and say, what is the nature of your business? What are your objectives? Where do you see this product going? Do you see it developing? Do we need to be thinking about perhaps getting a series of patent applications for different facets of your innovation? Or do we want to really try to block off, let's say it's a new pharmaceutical active, we're really trying to get a compound claim? Or are we looking at something that's perhaps a little bit more incremental, so we're looking at different formulation type of inventions and what have you? So that's a starting point. But then I'm thinking, because we're trying to support the business, in 5 years' time or 10 years or 15 years' time, are we looking to license this technology? Are we looking at maintaining an exclusive position? Are we looking perhaps at selling the business in 3 to 5 years' time, and we want to make the business look as sexy as we possibly can to prospective purchasers, in which case I might write a patent specification differently. I might include certain things, I might take other things out. So having a long-term view as to the overall objectives of the business and the business goals is absolutely essential before you put pen to paper. So I talk about sort of generation of a portfolio, but the generation of the portfolio requires you to bring together several different factors. So there is the invention aspect, which is the science. Of course, there's the legal aspect, because we've got constraints, if I'm writing the case just for the UK or for the European Patent Office, I'll have to put in certain things to the case. I'll have to have regard to certain requirements, such as how do we hold priority. In the European Patent Office, we have extremely strict rules as regards making amendments to claims during prosecution. So I need to think, at the time I'm drafting the case, what sort of information do I need to put into the specification at that time? And then if we're looking at that case probably going to the US, say Japan, India, Australia, Brazil, wherever it may be, at that very early time, I need, when I'm writing a patent specification, to be thinking, what are the sorts of things that I'm going to need in there? What exemplification do I need to get a decent scope of protection in China, for example? What do I need in terms of content in the patent specification to ensure that I've got a sound basis to argue for inventive step in the US, where we've got the 103 provisions that Raj referred to, as compared to, say, the European Patent Office, where we have to adhere to this approach known as the problem-solution approach that you may or may not have heard of. But it's a very artificial approach, but it nonetheless is the approach that the European Patent Office always applies when it assesses inventive step, both during prosecution and if your patent is opposed, you then have to defend your patent on the basis as to why the prior art does not render your claims obvious when viewed through the problem and solution approach. Now, you can only set out a proper foundation for what you're doing and the arguments that you might need to raise at the outset when you write the patent specification. As I say at the very outset, because in the European Patent Office, and I'm sure it's not too dissimilar in other countries, if you file a priority application and then file a later PCT application claiming that priority, you only hold priority for subject matter that is expressly disclosed in the priority application. So understanding what the scope and scale of the invention is, understanding what the commercial objectives are, these are all factors that you must have in mind when you're starting at the very beginning. And it's something that I refer to as cradle to grave. So further factors that are relevant, which I'll come on to with the next slide in a moment, are what are we looking at doing with the patents? Are we looking potentially at litigation? Are we going to need to think about evidential questions? How are we going to detect infringement? How are those sorts of things that we can acquire in the real world from a competitor's product or process, how are we going to embody those in what we say in a patent claim? So these are all thoughts that need to be brought into play at the very outset. So just go back. So what we have is the science is absolutely critical, of course, but also the law, the understanding of the different jurisdictional requirements. But most important, in my view, is the commerce or the business, and that is your fundamental underlying objectives. And you need to bring all of those particular factors together at the very beginning and integrate them in order to give yourself the best opportunity of developing assets that have genuine strategic value. Okay? And so it's very much a synergistic process. Next slide, please. Thank you. So it's what I term cradle-to-grave patenting. Drafting. As I say, at the beginning when I'm writing a patent specification, the fact that I've litigated patents in many cases in the UK, probably half a dozen cases in the US, cases in India, I've had 6 trials in the federal court in Sydney, the Tokyo High Court, etc., and many European national jurisdiction proceedings. All of those experiences feed back into what I do when I start to write a patent specification. I'm thinking about what is the end of life of the patent, what are we going to be doing in terms of exploitation and enforcement, what do I therefore need to be doing now, because once I've put pen to paper and it's been filed, that's it, we can't change it. It's a general rule that applies across pretty much all patent jurisdictions that you can't add subject matter, but you can remove subject matter, but you can't add it. So if it's not in there at the outset, you're potentially in trouble. So by not doing certain things, you can, and each one of these examples are things that I see every day when I look at patents that in my normal casework. Sometimes I'll see things where you've got a beautifully written patent that would stand up in the Supreme Court, but it's of no use to man the beast because no one is selling the product that is protected, or it doesn't clearly protect the product in its commercial form. So understanding what to protect and ensuring that protects and is supporting the business goals is absolutely essential. That's the one point to take away from anything that I say is that whatever you're doing at a legal level or a technical level when you're writing a patent is always have your eye on the commercial ball. Because if you don't, the whole purpose of what you're carrying out is could be lost. A step before that is simply not recognising opportunities or inventions are perhaps overlooked. I have an example where we've just got granted US patent for the most simple, inverted commas, of inventions for a client. And And the clients, they work in histology and cell pathology and what have you. And when one takes a sample, you put it into a small plastic cassette. It's a little rectangular cassette, a few millimetres depth. And these cassettes have a slot in the front. So you put a series of these cassettes into a machine, and then the cassettes basically pass through the machine successively. And so you have a stack of cassettes, and they need to move through the machine. Now, it's millions of these things are used. And our client came along and said, we've come up with this rather neat idea, but there's nothing in it at all. But we just thought you'd like to know, because we know that you like to be on top of what we're doing as a business. And what we have done is we've got a little bit of plastic tape, rigid plastic tape, that's a long strip with a little tail on the bottom. And what we have done is we feed that through the cassette, through the slot in the cassette, so we can basically thread a whole host of cassettes onto this tape and put it into the machine and pick up the top of the tape, and the little foot on the bottom of it holds the cassettes in place. And we can put that into the machine and then just pull it out, and they're in there, and they're all in register, and it's great. We decided that we couldn't find anything that disclosed that, but as simple as it was, the client had not even brought it to our attention beforehand, because they were certain there was nothing in there. And we've just managed to get a granted patent for them for that. Now, it's something which commercially could be of very great value. Technically, you look at it and it's not necessarily a huge innovation in a purely technical sense, but commercially it's very important. But it would have been very easy to have not recognised that there was an invention there. Another example involves detergents, where detergents typically might have a large box detergent might have a 450 grams per litre bulk density, and then small box detergents perhaps a 900,000 grams per litre bulk density. Uniquely, apparently, in the Argentinian market, the Argentinian, I would say housewife, but we can't say those sorts of things these days. The person doing the washing in Argentina apparently likes an intermediate bulk density product of 750 grams. The technical people were saying, well, clearly we're not going to be able to get a patent for that, because we're just mixing some dense stuff and some less dense stuff. But because we wrote a patent on that patent application, where we were able to talk about the complications and difficulties of the supply chain, where material is in a box for a period, sometimes for weeks, and there'll be issues of segregation and layering within the box, that it would not be an obvious thing to mix those things together. And sure enough, we managed to get a patent for that some time ago. So not recognising the invention is an absolutely major risk, and therefore, as an advisor, we would always urge our clients to simply have a close, open relationship with us. To enable that, we don't work on hourly rates with a lot of our clients. We work on the basis that we're a part of their business, and we will say to them, we will look after this portfolio for you, or this business area, for this period of time on this sort of fixed fee basis. That takes the money out of the question, so the client is not concerned about phoning us up because the taximeter's ticking, and it means that we've got a much closer symbiotic relationship, which means that we don't miss those sorts of things. So to come back to this, who are the competition and what are their plans? When I'm writing a claim, I need to understand exactly what the competition is likely to do. So we'll write claims not just to protect our invention, but if the competition has got, say, a particular way in which it formulates its pharmaceuticals, we will have claims to those sorts of things as well, for the simple reason that it gives a headache to the competition. That may not necessarily be determinative in terms of establishing an exclusive position, but what it gives us is an opportunity to negotiate with the competition. So it gives us leverage in a commercial context down the track. Supplier customer activity and marketing claims. At the moment, we're working with a client. It's a spin-out pharmaceutical company from Oxford University, and they have some incredibly exciting technology, and we've got product claims for them. But they keep finding further uses and further effects for their material. And so while some of these areas may in certain countries be marginal in terms of what is protectable, by writing claims which read onto those things, and there is at least an element of doubt of that as to whether we can get protection, what we nonetheless are doing is putting the onus on a would-be infringer for those folks to make the call as to whether there would be infringement or not. And so we, as the patentee, will benefit from the uncertainty and the conservative approach that the competitor will adopt. Their advisors will be saying, well, we think it's invalid, or we don't think you infringe, but we can't be sure. So that may add a little bit of a delay. It may give enhanced negotiating opportunities for us. So understanding what the competition are doing is absolutely critical. I'll just get to the end. Claims of the wrong type or scope. We're all familiar with product claims, components of products, compositions, applications, use, reach-through claims, for example. Absolutely critical, again, to ensure that you look at all different facets of the invention. So what claims are going to be relevant to your suppliers? Which claims are going to be relevant to your customer? Which claims are going to be relevant to your competitor? As well as claims that protect your own innovation. I've talked about awareness of global practices. So the final points really are that when you're writing claims, one needs to think about detectability of infringement. If you can't, you can write a claim that's beautifully crafted and will stand up in the court or what have you. But if you can't detect in the real world when infringement's happening, again, the commercial value of such a patent is significantly reduced. All of that will lead to a non-strategic portfolio. So by taking account of these factors when you're writing your initial patent application is a way, in our view, to create genuine strategic value in your patenting activity and justify the cost. And that's all I have to say. Thank you very much.
Thank you, Stephen. That